Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you were an activist and you find yourself at the receiving end of efforts by the military to link you to communist rebels. What can you do? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 31st of October 2024, and today we talk about red tagging and the Writ of Amparo, as discussed in the case of Deduro versus Vinoya, decided on July 4, 2023. It's an unbanked decision penned by Supreme Court Associate Justice Rodil V. Zalameda. And joining us to talk about this case are Attorney Ethel Torrio and Attorney Joyce Manongsong from the Office of Associate Justice Zalameda. Hi, Attorney Ethel, Attorney Joyce, thanks for joining us. Welcome to the Supreme Court Podcast.
Good afternoon. Hi, Attorney Mike. Hi, everyone tuning in.
All right, so let's talk about this. This is a landmark case. This involves the case of an activist from Iloilo. So, Attorney Joyce, tell us a bit more about Sigfred Dururo. Who is he?
All right. Sigfred Dururo is an activist and a former public servant. He is the founder and vice president of the Makabayan Coalition and Bayan Muna party list. He is also active in various environmental groups and people's organizations. He also served as a party list representative of Bayan Muna during President Macapagal Arroyo's term and also worked as a consultant with the Department of Agrarian Reform in 2017.
Right, so he has a long history of activism, but he has also worked in government. What prompted him to file a petition for the issuance of a writ of amparo? What were the allegations against him, and how were these disseminated?
All right. Deduro asked for judicial relief because he said that he was being red tagged in various instances by the military, specifically the 3rd Infantry Division and some other private individuals or entities. He believed that these instances of red tagging constitute as a threat to his right to life, liberty, and security. So with respect to the red tagging of the military, Mr. Deduro alleged two specific incidents. First was a meeting held on June 19, 2020 by the Iloilo Provincial Peace and Order Council or the PPOC, attended by the Iloilo City Governor, Governor Arthur Defensor, other public officials, military officials of the 3rd Infantry Division, and members of the media. So for this purpose, Deduro attached printouts of photos and articles from the members of the media who covered the event. The photos showed that his name appeared twice in the alleged network of people and organizations supporting CPP-NPA. So other than that, he also cited another event in August 2019 about a symposium conducted at the University of St. La Salle Bacolod, where members of the 3rd Infantry Division also showed photos of organizations, including Bayan and Bayan Party List, of which Deduro is a member, labeling them as communist supporters. So Deduro also attached photos of this event. As said earlier, Deduro also narrated other incidents where he and other activists were red tagged or threatened by unknown individuals and private organizations. First, in December 2017 and 2019, Deduro claimed that there were posters with his and other activists' photos displayed all over Iloilo City, saying that there were criminals, terrorists, and members of CPP, NPA, and DF. Also included in these photos were Jose Reynaldo Porquia, a Bayan coordinator, and Raylan Vergara, a high-ranking official of the Karapatan Alliance Philippines Incorporated. Another incident was in January 2019, where Deduro and his companions, one of which was Raylan Vergara, that they were allegedly surveilled by 3 unidentified men from a restaurant until they reached their office in Iloilo City. So, Deduro also alleged that after the June 2020 PPOC meeting, he was again red tagged, but this time in social media, particularly in the Facebook page of Western Visayas Expose. Zara Alvarez, who was a paralegal and education officer of Karapatan and Deputy Secretary General of Bayan Negros, was also similarly labeled on this Facebook page as part of the CPP, NPA, and DF network. To support his petition, Deduro attached photos of the posters that were allegedly put up in various locations in Iloilo City, a copy of the police blotter reported by Raylan Vergara, his companion at that time, and printouts of posts on the Facebook page of Western Visayas XPC.
Attorney Joyce, some of the names you mentioned, I recall from news reports that they were actually eventually killed. So when Mr. Deduro was included in this campaign to link him to these personalities as part of the CPP, NPA, how was he affected by these allegations?
So as he said, Deduro pointed out that his colleagues Perkia and Alvarez, who were also red tagged in the posters and in social media, were both violently killed. Since these victims were also repeatedly red tagged and allegedly surveilled before they were killed, he feared that he would suffer the same fate.
Right. So, okay, so where did he file his petition?
So Deduro filed the petition with the RTC of Iloilo City since majority of the supposed instances of red tagging happened there.
And let's go to the other side. Attorney Ethel, can you briefly walk us through who is this Major General Eric Vinoya and why was he named by Deduro as the respondent?
So, Major General Eric Vinoya was named as respondent in his official capacity as the commanding officer of the 3rd Infantry Division, Philippine Army. So, in his petitions before the RTC and also before the Supreme Court, Deduro made allegations that officers from the 3rd Infantry Division red tagged and labeled certain organizations and individuals. So, in his accounts of red tagging, as mentioned by Attorney Joyce earlier, there were two incidents that Deduro attributed to the 3rd Infantry Division, which Major Vinoya headed. So, we should note that there were also incidents where private organizations did the red tagging. However, Deduro did not name any of these organizations as respondents. But the Supreme Court, in its dispositive portion, corrected Deduro's error on this matter.
Mhm. So, in the allegations of Deduro, he blamed these incidents of red tagging to the military. There were some who were private. But how did Major General Vinoya respond to the allegations of Mr. Deduro in his petition?
So, Major Vinoya did not give any response to the Duro's petition before the RTC. So, in her discussion of the RTC's decision later, Attorney Joyce will tell us why this happened. But unlike the RTC, the Supreme Court asked Major General Vinoya to submit a comment to the
Mhm.
petition. So, with the Office of the Solicitor General as counsel, Major General Vinoya stated that De Duro failed to show a concrete link to any military unit or personnel who could have committed red tagging during the symposium at the University of St. LaSalle. He also declared that De Duro failed to establish that the red tagging list in the Iloilo meeting was from an official document produced and utilized by Major General Vinoya and his military personnel.
All right. So, Attorney Joyce, did the RTC not see any link between the allegations and the military as supposedly the perpetrators of these allegations?
Yes, Attorney Mike. So the RTC dismissed the Duro's petition outright. It did not issue a preliminary writ of amparo, and it did not even require the respondent, Major General Vinoya, to file a return. So for the trial court, the supposed several incidents of red tagging, the alleged surveillance by unidentified men, as well as the deaths of the other red tagged individuals like Perkia and Alvarez, simply did not prima facie establish threats to De Duro's life, liberty, and security as to justify the issuance of the writ. So the court found that the allegation that De Duro was followed by three unidentified men was not good enough to justify the issuance of the writ because there was no proximity in time to any supposed red tagging incident, and because, according to the court, it was De Duro's companion, Raylan Vergara, who reported the incident to the police and not him.
Deduro lost that RTC case, right? What happened when he appealed to the Supreme Court?
So, in its disposition of the case, the Supreme Court did four things. So, one, the Supreme Court partially granted De Duro's petition. The RTC's order of dismissal was reversed and set aside. So, what the Supreme Court granted was the issuance of a writ of amparo in favor of De Duro, returnable to the RTC. The writ was issued against Major General Vinoya in his capacity as commanding officer or his replacement in his official post if he has already vacated the same. Now, there are other matters in De Duro's petition that the Supreme Court did not grant and which were left for the determination of the RTC. First, the Supreme Court did not issue a production order because De Duro had asked that Major General Vinoya and his agents produced documents related to Deduro and or surveillance activities that they carried out. Second, the Supreme Court also did not enjoin Major General Vinoya and his agents from red tagging, approaching, monitoring, or harassing Deduro. There was also no order to Major General Vinoya and his agents to destroy records about Deduro, if any. So, second, Deduro was ordered by the Supreme Court to submit to the RTC within 3 days from notice a supplemental petition which impledes the Alliance of Victims of the CPP-NPA-NDF and the Western Visayas Alliance of Victims of the CPP-NPA-NDF. Remember that the respondents in a petition of a writ of amparo are not limited to public officials or employees. Even private individuals or entities may be named as respondents. So in this instance, for a complete resolution of the matters raised by Deduro, the Supreme Court asked him to include the private organizations which he mentioned in his narration of red tagging. 3. The Supreme Court ordered all respondents to make a verified return with the RTC within 72 hours from receipt of the writ. And 4. The Supreme Court required the RTC to conduct a summary hearing on Deduro's petition for the issuance of the privilege of the writ of amparo and the interim relief of production order within 10 days from its receipt of the decision. So after hearing, the RTC shall decide the case within 10 days from the time it is submitted for decision and furnish this court with a copy of the decision within 5 days from its rendition. So the Supreme Court en banc promulgated its decision on July 4, 2023. The decision was unanimous. All 15 Supreme Court justices agreed with the disposition, and Senior Associate Justice Leonen filed a concurring opinion.
All right. So, Attorney Ethel and Attorney Joyce, for us to be able to understand um, red tagging and its relationship to the writ of amparo, let's first take a look at this writ of amparo. Tell us, what is this about? What does this remedy do? And when is it applicable?
Okay. So if you look at the rules, it defines writ of amparo as a remedy available to a person for violations or threats of violations of the right to life, liberty, and security by an unlawful act or omission of a public official or employee or of a private individual or entity. So in this matter, it's also important to mention the Supreme Court's discussion in the landmark case of Secretary of Defense versus Manalo. So we also cited this in the Deduro discussion because that case traced the origins of the rules on writ of amparo. And in that case, the Supreme Court discussed that the remedy of writ of amparo was meant to fill the gap in terms of remedies that can specifically and effectively provide judicial relief to enforce disappearances and extrajudicial killings or threats to commit such act. So the Supreme Court said in that case that the writ of amparo is a remedy which provides rapid judicial relief as it partakes of a summary proceeding that requires only substantial evidence for the grant of relief. So it is not a criminal action requiring proof beyond reasonable doubt. It is not a civil case requiring preponderance of evidence or an administrative case requiring substantial evidence that will require full and exhaustive proceedings. So as it was meant to fill the gap, so to speak, it is also important to say that it is not a substitute for other remedies. Its function, as we said in Deduro, is to cause disclosure of details concerning extrajudicial killings and enforce disappearances or threats of such acts. So respondents' actual liability, civil, criminal, or administrative, can be determined in another proceeding.
So, in this case, Attorney Joyce and Attorney Ethel, there was an issuance of a writ of amparo, which in essence just requires um, the respondents to file a return, and it directed the CA to conduct a hearing. How is the issuance of a writ of amparo different from the eventual privilege of the writ of amparo, which is issued after the whole proceedings?
So, for the lawyers and law students listening, so this is similar to our discussion in constitutional law about the writ of habeas corpus and the privilege of writ of habeas corpus, if you recall that. So essentially, the court, in case of the issuance of a writ of amparo, it determines whether during the initial stage or after the filing of the petition, um, it determines whether there is a prima facie case, which means that it determines whether petitioner's right to life, liberty, and security has been violated or threatened to be violated by an unlawful act of the respondent. Whereas if we talk about privilege of the writ of amparo, it is granted after the entire proceeding. So after weighing of the allegations and evidence of both parties. So if you look at the rules of procedure of a writ of amparo proceeding, it is granted or denied after the filing of the return, the conduct of the summary hearing, and an exhaustive determination of the court on whether there is substantial evidence to support the petitioner's case.
So right, we've now distinguished. Uh, we've now distinguished the writ of amparo from the privilege of the writ of amparo. Let me go to now the process of red tagging. First off, how do we define red tagging, and how is this manifested in this particular case?
So let's look at the two components, so red and tag. The word red has been associated with communists, destabilizers, terrorists, anti-government or anti-establishment forces. On the other hand, tag refers to the acts of branding, labeling, or associating. So the compound word red tag, as used in the Philippine context, is to label individuals or organizations as communists, destabilizers, terrorists, without regard to their actual political beliefs or associations. So how does red tagging happen? The Supreme Court decision in Deduro cited an example. A Mandaluyong judge dismissed a case and ordered the release of two detainees. One detainee was a journalist, while the other one was a trade union advocate. Soon after the dismissal of the case, a tarpaulin was set up here in Metro Manila, Shaw Boulevard, corner EDSA. The name and the face of the judge, as well as the branch number of her court, was prominently displayed on the tarpaulin. The logos of the Communist Party of the Philippines, the National Democratic Front of the Philippines, and the New People's Army were also there. The text on the tarpaulin read, "Maraming salamat, Judge, sa mabilis na paglaya ng kasama natin. Ituloy ang laban mula sa CPP, NPA, NDF." The tarpaulin made it appear that the judge is a kasama or a member of the CPP, NPA, NDF, and that these organizations were thanking her for the disposition of the case against her colleagues. There was no consideration at all of the contents of the decision. The judge was already seen as a member, or at the very least, sympathetic to communists and destabilizers, because she rendered a decision favorable to two of their alleged members. The court's decision in Deduro went back to the definition and illustration of threats in Secretary of National Defense versus Manalo, a 2008 case penned by then Chief Justice Reynato Puno. This case introduced the concept and purpose of the writ of amparo in Philippine jurisprudence. Manalo mentioned a number of cases from foreign jurisdictions which ruled that death threats, intimidation, harassment, restriction of movements, and discrimination violate the right to security. So the Supreme Court's decision in Deduro highlighted that red tagging has been acknowledged by international organizations as a form of harassment and intimidation. Currently, like in the decision, we recognize that the practice of red tagging has transitioned to online media platforms like Facebook. Labeling is often accompanied by surveillance and direct harassment. Death threats can be received through text messages or online direct messages. Women targets have been threatened with rape or other forms of sexual assault. While some of those who have been red tagged remained as threats, there are some red tagged individuals like Porquia and Alvarez who were eventually killed. Therefore, a person may, in certain circumstances, develop fear that being red tagged places his or her life or security in peril.
Hmm. So can we confirm, Attorney Ethel, that this is the first time that the Supreme Court of the Philippines has defined red tagging, at least in the Ponencia?
Yes. This the Duro is the first time that Supreme Court defined red tag in a main opinion. But then allow me to qualify
Please
this
go ahead.
answer.
Mhm.
So we use the term red tagging in the same manner as red baiting and terrorist tagging. Now these phrases have previously been used in two other cases. First is the separate dissenting opinion of then Associate Justice Leonen in the unsigned en banc resolution in the 2015 case of Zarate versus Aquino. The second, the second instance was the term red tag is found in the main opinion of Justice Carandang in the en banc decision promulgated in 2021 of the consolidated cases in Calleja versus Executive Secretary. So this is the Anti-Terrorism Act cases. So in then Associate Justice Leonen's separate dissenting opinion in Zarate, he used the term red baiting. He defined red baiting as the phenomenon of implicating progressive civil group leaders to heinous crimes. The phrases red tagging and red baiting were used by some of the petitioners in Calleja who claimed to have been red tagged. So, one petitioner, Sisters Association in Mindanao or SAMIN, asserted that their members experienced harassment due to their critical stand against the militarization of Moro and Lumad communities. Another petitioner, Gabriela, claimed that they have been targets of human rights violations committed by state forces and are constant targets of red baiting and red tagging.
So you mentioned Senior Associate Justice Marvic Leonen and his separate opinion in Zarate versus Aquino. In that case, he used the term red baiting. How is this comparable to the concept of red tagging or McCarthyism?
Okay, so we should first make it clear that the comparison of red tagging and McCarthyism, it was not extensively discussed in the text of the Deduro's decision. So the decision described the problems attendant to red baiting and the remedy made available by the rule on the Writ of Amparo. To provide the background for the benefit of the listeners of this podcast, McCarthyism is a term which referred to the campaign of spreading fear of communist and Soviet influence on American institutions. So on February 9, 1950, in a speech before the Republican Women's Club of Wheeling, West Virginia, then United States Senator Joseph McCarthy claimed to have a list of 205 names of members of the Communist Party who were working for the State Department. Later on, there were investigations carried out by committees in the United States Senate, in federal, state, and local governments, and even in private agencies to identify possible communists within their organizations. So the acts of fear mongering, as well as of making unsubstantiated accusations regarding a person's supposed associations and political beliefs, became associated with Senator McCarthy, hence the term McCarthyism. So the Supreme Court's main opinion in Deduro reproduced a portion of Senior Associate Justice Leonen's separate dissenting opinion in Zarate and said that red baiting is our version of McCarthyism. It proceeded to explain that vocal dissenters of the government are stereotyped and named as masterminds of criminal acts. So the terms McCarthyism, red tagging, red baiting, they are similar in the sense that individuals or groups are labeled and made subjects of unsubstantiated accusations so that they become objects of ridicule, contempt, and hate by the general public. Because of this vulnerability, there are threats to the life, liberty, and security of red tagged individuals.
Attorney Ethel, if you are red tagged, does that necessarily entail a threat or danger to your life or security? Is that what the Supreme Court is saying here? How dangerous is red tagging based on the discussion?
So, in a practical sense, red tagging is dangerous because it has become a precursor to extrajudicial killings or enforced disappearances. Mere association with communists makes the red tag person a target of vigilantes, paramilitary groups, or even state agents. Given the situation, a red tagged person may fear that being red tagged places his or her life or security in peril. A senior associate Justice Leonen said in his separate opinion in Deduro, the heightened risk of danger or death brought about by being labeled as a communist sympathizer, or even merely being adjacent to a communist cause should be seriously considered by judges in amparo proceedings.
Attorney Ethel, given this discussion on the writ of amparo and on red tagging, how did the Supreme Court evaluate the case of Mr. Deduro?
So, First, the Supreme Court agreed with the RTC that petitioner's allegations are threats to life, liberty, and security. That there was no violation to his life, liberty, and security yet.
Mhm.
He was still alive. He was not a victim of an extralegal killing. He is still present. He is not a victim of an enforced disappearance. So it was correct that petitioner's allegations were classified as threats to his life, liberty, and security.
Right.
Now, second, and this is where the Supreme Court reversed the RTC, is that the allegations of the petition were deemed to be sufficient to merit the issuance of a writ of amparo. So what was given importance here was Deduro's right to security. So in terms of substance, we have to put in context the dangers of red tagging and go back to the roots of the right to security. Now, students of constitutional law will do well to recall Chief Justice Puno's brilliantly exhaustive separate opinion in Republic versus Sandigan Bayan, where he adverted to two major international human rights instruments. Now, he did the same in Secretariat of National Defense versus Manalo. So the Supreme Court relied on the UDHR, Universal Declaration of Human Rights, and on the ICCPR, International Covenant on Civil and Political Rights. So both of these instruments provide for the right to security of a person. Now, the petition was also found to have given prima facie evidence, or the quantum of evidence required for the issuance of a writ of amparo. There was a prima facie link to Respondent Major General Vinoya and his subordinates. The Supreme Court did not rule whether Deduro was entitled to the privilege of the writ, and it was left for the RTC to decide. So the Supreme Court found that the allegations of his petition were sufficient for the issuance of the writ, and that Deduro alleged facts that constituted threats to his life, liberty, and security, and he was able to submit evidence to corroborate his allegations. So finally, what constitutes threats varies from every individual petitioner's circumstance. Membership in a non-government organization or inclusion in an order of battle of the military by themselves do not equate to actual threats. As the Supreme Court considered the tarpaulin congratulating the Mandaluyong judge as a threat, it also considered a similar tarpaulin which declared alleged ties between the named persons and the CPP and PANDF as a threat. The Supreme Court was emphatic in declaring that it does not view the lives of civilians as less precious than that of judges.
Okay, so the Supreme Court is saying here that being a member of the organization is not in itself the threat that constitutes, that warrants protection, but it's being publicly named as a member of that particular organization, which we all know now has been designated as a terrorist group by the Anti-Terrorism Council. So just to sum up our discussion, Attorney Ethel and Attorney Joyce, what's your biggest takeaway from this case? We know that this is the first time that red tagging has been recognized or defined by the Supreme Court in the main opinion, but significantly, it also says red tagging can be a justification or a ground for invoking the writ of amparo.
Okay, so the most important pronouncement in Deduro is that red tagging constitutes as a threat to a person's life, liberty, or security, which can justify the initial issuance of a writ of amparo. So we would just like to clarify that we did not here rule whether Deduro is entitled to the privilege. We just resolved the issue regarding the issuance of the preliminary writ of amparo. So, as long as the petition sufficiently alleges and establishes that the aggrieved party is being red tagged by the respondent and that similarly red tagged individuals are either threatened, harassed, or killed, then the courts must not summarily dismiss the petition, issue a writ of amparo, order the filing of return, and conduct a summary hearing.
Alright, so for those who are being red tagged, the writ of amparo is now a clear remedy. It does not wait until you are summarily disappeared or you've been killed. As long as there is a threat, you can invoke this writ.
Yes, that's correct.
All right. So thank you so much. This has been an exhaustive discussion with you both, Attorney Ethel and Attorney Joyce. Thank you so much for joining us today in our podcast.
Thank you, Attorney Mike. Thank you, Supreme Court PIO, for the opportunity.
All right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Deduro versus Vinoya, GR number 254753. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court en banc, during its session on October 29, 2024, issued a temporary restraining order, or TRO, against the further transfer of PhilHealth funds to the National Treasury. The court also consolidated the petition filed by Isambayan Coalition et al. With the cases of Pimentel et al. Versus House of Representatives et al. And Bayan Muna Chairman Nery Colmenares et al. Versus President Ferdinand Romualdez Marcos. All three petitions challenged the return of excess reserve funds of government-owned and controlled corporations to the National Treasury to fund unprogrammed appropriations. The court also required respondents to Isambayan's petition to file their comments on the petition and application for TRO and/or writ of preliminary injunction within a non-extendable period of 10 days from receipt of notice. The Supreme Court will be hosting the 11th meeting of the Council of ASEAN Chief Justices, or the CACJ, on November 18 to 21, 2024 at the Shangri-La Mactan, Cebu. The meeting will bring together Chief Justices and senior judiciary officials from ASEAN member states to discuss judicial cooperation and regional initiatives in Southeast Asia. Among the matters that will be discussed at the CACJ meeting are cross-border disputes involving children, facilitating service of civil processes within ASEAN, case management and court technology, conduct of video conference hearings, and judicial training and education. Interested participants for the Metro Manila leg of the proposed amendments to the Rules of Civil Procedure regional consultations to be held on November 8, 2024 at the De La Salle University, Manila may still register, as the registration deadline has been extended until November 5, 2024, 12 p.m. The regional consultations aim to engage various stakeholders, including judges, legal practitioners, and the academe, in discussing proposed amendments to the Rules of Civil Procedure. To register, visit the Supreme Court website. The Supreme Court has ruled that remittance to the GSIS of employees' contributions is not part of a mayor's duties. The court acquitted Antonio Talawe, former mayor of the municipality of Santo Tomas in Isabela, of violation of the GSIS Act for the municipality's failure to remit to GSIS premium contributions. The court ruled that under the Local Government Code, municipal mayors are considered chief executives and not the heads of office mandated by Section 52, Paragraph G of the GSIS Act to remit contributions. Neither does the list of a mayor's duties in the Local Government Code include the duty to remit such contributions to the GSIS.
And that's your Supreme Court this week. I am Tiff Atendido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Don Ryan Balza, Henry Camba, and Victor Laranio as sound editors, and Tyke Flores as web editor.